Okay, good afternoon. My name is Michael Paris. I teach in the Political Science Department here. I'm also the pre-law advisor for the college. Welcome to our second lecture this semester on academic freedom. I'm going to start with a few preliminaries before we get to our distinguished guest and our distinguished commentator. I'd like to there are going to be some people coming in over the next 5 minutes or so I just want to say a few words about our pre-law activities and our legal studies program. If you're a student and you're interested in law school, you should find me and talk to me as soon as you can. The Legal Studies Institute is here to provide a set of opportunities and resources for students interested in careers in the law and related fields. I like to say we're devoted to doing our part to provide students with a fair shot at the American dream. And we have various aspects of the program. We have a minor in legal studies. We do one-on-one pre-law advising for all students and graduates. We have workshops for students that provide practical knowledge about the law school admissions process and careers in the law. We do internship placements for credit and over the summer for a few students for pay. And we host public lectures like this one to enhance the intellectual environment of the college. We have some funds. The Scammerdella law firm, Bob Scammerdella is a graduate of this institution in 1972. He runs a mid-sized law firm on Staten Island. He's provided resources to fund some summer internships and to reimburse students for expenses, up to $500 for the process. We also have an endowment that Dan Kramer's widow, Rashenda Kramer, largely funds. Dan Kramer taught here for 40 years or so, and this endowment funds a lot of things. Most recently, it's funding this in-progress renovated student space. So we do stand on people's shoulders. Kramer is a Harvard Law grad, got his PhD in politics from Penn, and he's a real mensch. Died a little bit young, about 15 years ago. I want to thank, you can see that many students are coming in. I want to thank these folks, the CSI Student Pre-Law Club, the student government. Wonderful, thank you. It's always amazing to me. Like I show up tonight, I forgot my notes, right? So they had to be printed. Dave Pizzuto and his media team for recording this event. Carolyn Gianola and Auxiliary Services has set up a wonderful reception. Please join us afterward upstairs to continue the conversation. Joe Cipoletti for tech support here. Dana Trimboli and Cheryl Adolph at the CSI Foundation. And also, not on the list, but should be, is the PSC CUNY, co-sponsoring this event and fighting the good fight. I'm proud. I have my proud union button on today. So, I usually run through some of our student success stories, but in the interest of time, I'm going to forego that. Let's get serious, because this is a serious topic. We're gathered here today to consider and discuss academic freedom. That we do affirms the value of academic freedom itself, whatever differences we have, and we will and always will have differences. The idea of academic freedom is perennially contested, and today very hotly contested. And today many believe, as I do, that it's pretty much everywhere under attack. Faculty members face harassment, punishment, sometimes termination of employment for the expression of political beliefs, whether intramural or extramural expression, and we'll get into that later. A so-called Stop Woke Act in Florida mandates not only what may be taught, but how it may or may not be taught. The Trump administration withholds massive amounts of funding, federal funding, unless universities capitulate to its ideologically driven demands. And some capitulate, and some fight back. These are indeed perilous times. However, in the true spirit of academic freedom, our first task here today is to try to understand it. What is academic freedom exactly? Where does it come from? How and why and to what extent is it protected by the First Amendment of the Constitution or by widely shared norms that have to do with the First Amendment? To help us understand, we are delighted to be joined by Professor David Rabban of the University of Texas Austin Law School. Professor Rabban is the author of this remarkable book, Academic Freedom, From Professional Norm to First Amendment Right, published last year by Harvard University Press. It's painstakingly researched. It's extraordinarily well-crafted in terms of its argument. It's measured, it's thoughtful, it's constantly provocative and informative. And I don't think Professor Rabban will be insulted if I say I do not recommend that you take this book to the beach. It demands something of you as a reader. It actually asks the reader to practice the virtues that it itself extols. Right? It requires some patience and some attention, but it's well worth it. Go out and buy this book if you're interested in this topic. It's comprehensive and marvelous. And we are delighted to have our own colleague and scholar and teacher, Professor Ashley Dawson, with us today to join in the conversation, make some comments, ask some questions. Professor Dawson is in the English department. He's the author of many books. I'm not going to do the CV if you don't mind. But he is CUNY Distinguished Professor. There are 146 of those out of about 7,000 CUNY faculty members, so it's quite an honor. Ashley, I thought you were distinguished before you became Distinguished Professor, but now you're super distinguished, right? So thank you for joining us. How we're going to proceed, I'm going to walk Professor Rabban through the argument of the book, or I'm going to try to, through some interview questions. So we're going to do an interview format for that part, then we'll hand it over to Professor Dawson to make some comments or ask some questions. I've told Professor Dawson he can jump in anytime. We're going to just have a conversation up here. There'll be plenty of time for Q&A, so keep your thoughts and your questions in mind. And please do join us to continue the conversation after. We'll talk with Professor Rabban about his career and his commitments in the course of the program. He's the author of a previous book, The First Amendment in Its Forgotten Years, a very well-received book some years ago. So please join me in welcoming Professor David Rabban to the College of Staten Island. Okay, David, I think I want you to sit in that chair. Okay, so we're great. Ooh, okay. Welcome. Thank you for coming.
Thank you for inviting me, and thanks for that wonderful introduction.
Quite welcome. True, all true. So let me begin with you. The historian E.H. Carr once famously wrote that before you, I am paraphrasing here, before you read the history, you should know something about the historian. So could you tell us a little bit about yourself, your career, what brought you to write this book, your background? And I have a sense that it does sort of telescope to this kind of work, that you've had a whole career in this field.
It does. I was interested in issues of free speech and academic freedom as a college student and as a law student. I worked in New York City in my first job for a labor relations firm, union side, and Soon after I took that job, I saw an ad for a position with the American Association of University Professors, and I applied for and received that job. So starting as a young lawyer, I've worked on issues of academic freedom my entire professional career. I moved from, it's called the AAUP, American Association of University Professors. I moved from there to the University of Texas, where I've always taught courses in higher education and law, and I've always intended to write a book about academic freedom. And it took me a long time to get to this project, but I'm glad I finally did. I started this book 10 years ago, and it's taken like most of those 10 years to finish it, because I wanted to do a comprehensive survey of all legal cases that have dealt with academic freedom. That takes a long time to do and to kind of boil down. I never expected that the book would be published at a time of such great national controversy and concern about academic freedom. But I'm glad my book now is available to be part of that conversation, including today.
Yes, and the 10 years of work really shows. It's really here. You can feel it. It's painstaking. It's comprehensive, but it's also accessible.
You know what's also painstaking? To have to cut a fourth of it, doing all the work, all the writing, and then realizing with the help of an editor and colleagues, it would be better if shorter, and I hope that's true.
Well, yeah, I think it is. So it's wonderful. This is a big topic, academic freedom, and it has many dimensions. So if you could just give us a sense of its dimensions, its sort of sub-issues, its categories. Like, what are we talking about when we talk about academic freedom before we get to the argument of the book?
Well, there's some debate about that, and a big issue is, like, who has academic freedom? So originally, academic freedom was developed as a right of professors and universities, with its own justification. We'll get into that, I'm sure. It's also, academic freedom has been extended to rights of universities as institutions. Sometimes the rights of professors and the rights of institutions conflict. So there can be conflicting academic freedom rights. And there's been some discussion and even some judicial recognition of academic freedom as a right of students, though it's a different kind of right than for professors. So who has it? Also, like, what's its scope? What does it cover? Purely academic speech? Speech about issues facing the university? Speech about political issues? There's a lot of debate over how far academic freedom should extend.
Yeah. Okay, thank you. And also, like, intrusions from outside.
Yes.
The big topic today we'll get to.
Right, and there are intrusions on professors and on universities.
Okay, so the book traces the development of the idea of academic freedom, which comes first as a right of professors. And it charts what I would say is really its migration into First Amendment law in an odd kind of amorphous way, more up in the air and opaque than one might think. But there is a cornerstone to your argument, and do correct me if you think I'm mischaracterizing the work, but you rely a lot on, build on this 1915 declaration from the kind of recently formed American Association of University Professors. It's called the Declaration of Principles on Academic Freedom and Academic Tenure. Can you tell us a little bit about the 1915 declaration and the role it plays in your argument?
Yes, so the 1915 declaration was formulated by the AAUP in the first year of its existence, 1915, and it grew out of controversies about academic freedom in preceding years. Maybe we'll get into them a bit later. It remains, the 1915 declaration remains the best justification for academic freedom that exists in the English language, in my opinion. And the 1915 declaration and its analysis of academic freedom has been the basis for many university regulations covering academic freedom. So the provisions dealing with academic freedom in university handbooks and collective bargaining agreements derive in large part from this 1915 declaration. And its central argument, should I just briefly characterize that? The basic argument of the 1915 declaration is that in order for professors to perform the function they're hired for, they must have academic freedom. The function of professors, according to the 1915 declaration, is to use their expertise gained through long years of study to pursue knowledge and to disseminate knowledge. And this pursuit and dissemination of knowledge, the 1915 declaration argues, is a benefit for the entire society. The entire society benefits from expert knowledge. Professors cannot perform this function, according to the 1915 declaration, if they can be fired for reaching expert conclusions that offend others, whether they be administrators, trustees, state legislators, members of the executive branch of government, or their fellow professors for that matter. You can't pursue and disseminate knowledge effectively if you can be fired for your expert views because they offend others. That is the core argument for academic freedom in the 1915 declaration, and in my view, it should be the core argument for academic freedom under the First Amendment of the Constitution.
Okay, thank you. So we're going to have to fast forward a little bit here. There are a couple of chapters about historical developments and 19th century cases and things like that. But I'd like to fast forward to sort of the two key moments where we see the migration into First Amendment jurisprudence. So in Chapter 3, you talk about two leading cases. There's the 1957 case involving the Marxist economist Paul Sweezy, and the 1967 case involving a professor named Harry, I think it's Keishian?
Yes, that's it. Right.
Keishian, yes. A professor who refused to sign or take a loyalty oath.
In New York State. I think he taught at SUNY Buffalo.
Buffalo, right. Yep, SUNY Buffalo. So how do these cases figure in? Why are they so significant? Why are they the kind of the starting point for anyone interested in this issue as a First Amendment issue?
Right. So the Sweezy case, which was decided by the Supreme Court of the United States in 1957, was the first time that the U.S. Supreme Court identified academic freedom as a First Amendment right. Many of you probably know, the First Amendment covers rights of free speech. It doesn't specifically refer to academic freedom. In fact, there was no idea called academic freedom when the First Amendment was ratified in 1791. In the Sweezy case in 1957, the Supreme Court said that academic freedom is covered, protected by the First Amendment. And I think just a little bit of background of the Sweezy case is important to understanding it and its significance today. So, as you heard, Paul Sweezy was a Marxist economist. He co-wrote a very famous book called Monopoly Capital. He was invited to give a guest lecture at the University of New Hampshire. Okay. This was during the height of the Cold War and concern about communist subversion in the government. New Hampshire had passed a law, the state legislature passed a law authorizing the state attorney general to investigate whether subversive people were employed by the state of New Hampshire. And in pursuing this responsibility, the state attorney general called Paul Sweezy to testify. Sweezy was asked many questions. And he answered many questions from the state attorney general. But there were two categories of questions that he refused to answer, and he relied on the First Amendment as justifying his refusal. One set of questions had to do with his wife's activities in the Progressive Party, which was a left-wing party in the United States in the late 1940s and 1950s. The second set of questions had to do with the content of his lecture at the University of New Hampshire. For example, the state attorney general asked him, "Is it true that you advocated Marxism in your lecture? Is it true that you advocated the theory of dialectical materialism in your lecture?" Sweezy refused to answer those questions, claiming First Amendment protection. The Supreme Court upheld Sweezy's right not to answer these questions, referring to his First Amendment rights of quote-unquote political expression and quote-unquote academic freedom. And I think it's obvious that the nature of the questions led to the separate identification of academic freedom and political expression, right? Academic freedom had to do with his refusal to answer questions about his lecture. Political expression had to do with his refusal to answer questions about his wife's political activities in the Progressive Party. The Kieshian case, 10 years later, involved state legislation and regulations in New York, regulating what you could teach, including, theories of Marxism. And in upholding the right of a professor to teach Marxist theory, the Supreme Court struck down this legislation and used a quotation that has been often cited in subsequent cases. In the Kieshian case, the Supreme Court said academic freedom is quote unquote a special concern of the First Amendment. A special concern of the First Amendment. And that phrase has been cited in hundreds of subsequent decisions since 1967. Though the courts have barely elaborated how academic freedom is special. It's very frustrating.
Right, and that's elaborating how and why is what this book is about, which gets us into, it's a kind of a technical point, but I don't think we can do without it. So I'm gonna try it, and I just sort of set this up. In chapter 4, the book turns to the development of academic freedom, and I have it written here as a special concern of the First Amendment after 1967. So it's here that you develop your central claim that it is, or really should be viewed as. No court has explicitly adopted this theory yet and written it out this way, so maybe they will, right? Hopefully, right?
Let's hope.
You hope.
Not because it's my theory, but because it's right.
Yes, absolutely. So you say academic freedom should be viewed as a distinctive subset of First Amendment law, with general First Amendment concepts and categories adapted to the higher education context, which Professor Rabban in turn draws from the 1915 Declaration to a large extent. The nature and application of this distinctive right must draw on the central social values promoted by academic freedom. Right? Now, the theory of academic freedom as a distinctive First Amendment right draws meaning through Professor Rabban's contrast between his view, that view, and two other approaches that he views as inadequate. One of the other approaches is to simply generally apply First Amendment doctrine to the academic setting, writ large, without refinement. And the other concerns this weird body of jurisprudence called public employee speech jurisprudence. What rights do public employees have in public institutions generally to speak or not to speak or to have their speech controlled? and to be punished for it. So, what are the two other approaches? Why are they inadequate? And how is your distinctive theory distinctive?
So there's a lot in that question, and I'll try
I'm
to
sorry,
answer.
I knew, this might be a mistake, but let's try it.
Let's try it.
Yeah.
So, first point I want to emphasize, right? If academic freedom is the same thing as free speech, there's no need for a special theory of academic freedom. Why even refer to academic freedom as covered by free speech if academic freedom is the same thing as free speech? For academic freedom to have any meaning, it has to be distinctive from free speech in some way. In my view, what makes academic freedom distinctive is this theory from the 1915 Declaration. That is, professors need to have special protection called academic freedom to express, I want to underline, their expert views related to the search for and dissemination of knowledge. Unless professors have academic freedom, they can't do that job, as I said earlier. And I think this theory, it's in the 1915 Declaration, maps on to the general First Amendment value in producing and disseminating knowledge. Many First Amendment cases in many areas, not just universities, in cases involving the press, in other cases, have emphasized that part of the value of the First Amendment is to protect knowledge, which is what academic freedom does. So that's how academic freedom is different from free speech and relates to the First Amendment. So I hope that's basically clear without being too technical. I'm kind of looking around, and I'm just going to hope it is. People can ask questions later. Now, differentiating academic freedom from these other areas of free speech law, which sometimes are applied to facts where a special theory of academic freedom should be applied but aren't. Okay. One general free speech principle, free speech rights that involve everybody, is that the government cannot make decisions about what speech to allow and what speech to prohibit based on the content of the speech or the viewpoint of the speaker. So to take kind of an obvious, but I hope good example, you can't protect speech by Democrats and not protect it by Republicans. That is content-based distinction and viewpoint-based distinction that is impermissible. So, okay, does that apply to academic life? No, it doesn't. Your professors make content and viewpoint-based distinctions all the time in grading your papers. Like, is this content or viewpoint, does it meet academic standards or not? Hopefully they shouldn't be grading you on whether they agree with your viewpoint or not. That would be incorrect and violate the First Amendment. But to say that, like, your expression of your viewpoint is a B, not an A, that's what they should be doing. Access to university facilities. For example, it was a case involving a student organization denied access to university facilities. And one of the judges emphasized that a university should legitimately decide whether a particular use of university facilities has educational value or not. And to make that distinction based on content not only should be allowable, it should be done by a university in the promotion of educational values. So that's an example of how general free speech law doesn't map on well to free speech issues that can come up in a university. Even like more harmful to the interests of academic freedom is the development of what's called, as you said, employee speech jurisprudence. the law related to the speech of public employees, who include professors employed by state universities. There's a difference between state universities and private universities in the First Amendment. I guess we'll get to that later. But for now, the general point is, well, let me just first say, until the 1960s, public employees had no First Amendment rights. And the legal theory was, people have First Amendment rights as citizens to say what they want to, like on a public park, or write what you want to. Nobody has a right to be a public employee. And the theory was, it was articulated by the famous Judge Oliver Wendell Holmes, the state can require people to waive their First Amendment rights as citizens in order to get the benefit of a government job. In a case involving a police officer, public employee involved in politics, Holmes typically, tersely, snidely said, the police officer has a right to free speech. He does not have a right to be a policeman. And that was called the right-privilege distinction. That law was overturned in the 1960s by the Supreme Court in a case involving a school teacher. And the court said, citizens cannot be forced to give up their First Amendment rights as a condition of public employment, or as a condition of other public benefits, such as public housing, for example. And instead of the old right-privilege distinction, this was called unconstitutional conditions law. The state cannot condition a public benefit on the waiver of a First Amendment right. Point one, very important. Point two, however, the state as employer has some legitimate interests in restricting the speech of its employees in order to make public employment and public agencies function properly, that the state as sovereign, as governor, does not have interest in regulating the speech of citizens. So if speech by employees at work is disruptive and makes it hard for the agency to get its work done, that speech isn't protected. So it's extending speech to public employees from the old law, but also limiting their speech rights compared to citizens generally. So I hope that's clear.
Yeah.
In the same decision, the court emphasized that to be protected under the First Amendment, speech by public employees has to be about a matter of quote-unquote public concern. So here's where it gets to university professors. Some courts have decided that various speech by professors that would be protected under a theory of academic freedom is about a matter of private concern, not a matter of public concern, and therefore is not protected by the First Amendment. For example, abstract theorizing. That's the core of what many professors do. It's the basis for knowledge. But according to some courts, the public isn't interested in that. It's a matter of private concern, not protected by the First Amendment. Speech by a professor criticizing educational decisions made by administrators. You know, it's a matter within universities, it's not a matter of public concern. A complaint by a professor that she was denied tenure in violation of her academic freedom. It's an employee dispute, it's not a matter of public concern. So this is a way in which general employee speech jurisprudence is used to deny protection to professors that would be given under a theory of First Amendment academic freedom. Now, I also want to say some courts construe public concern more broadly in ways that would cover this speech by professors, but many courts do not. Final point on this issue. Another doctrine in employee speech jurisprudence is that public employees are not protected by the First Amendment when they speak, quote unquote, pursuant to their official duties. Even if it's about a matter of public concern. When I was general counsel of the AUP, I told myself part of my job was to look at every case in which the Supreme Court agreed to hear the case, just to see if the case might have implications for professors. Okay, this case involved an assistant district attorney in Los Angeles who felt that the district attorney had improperly received a warrant, a search warrant. According to this assistant district attorney, false facts were presented in obtaining that search warrant. And according to the district attorney, the office should ask the judge to withdraw the warrant based on an appreciation of the real facts, okay? And the assistant district attorney then claimed that he was denied a promotion and transfer in retaliation for making this point. And the issue the Supreme Court took the case on was, right, is speech pursuant to official duties protected by the First Amendment? Because the city of Los Angeles took the position that they weren't. Okay, so I'm a lawyer for the AUP. I read about this case. Doesn't involve professors. But I'm thinking to myself, what are the official duties of professors? Well, at the core, they're teaching and research. Precisely what the First Amendment law of academic freedom had been protecting ever since 1957 was now under jeopardy. And I told the political leadership of the AUP, who have to approve briefs, I think we should file a brief in this case. And we should also say, the First Amendment should not adopt this pursuant to official duties test. It's a bad test for everybody. You know, it means, you know, if you're, say, a police officer and complaining about police misconduct, and as part of your duty to complain if you see misconduct, you're not protected by the First Amendment. Is that a good law? Or an elevator inspector, you know, who finds, like, defective machinery and reports it, could be fired for doing that because it's pursuant to official duties. So I said, we should challenge this general law, but we should also say, whatever Supreme Court you decide in general, you should not, if you adopt this test, which you shouldn't, please don't apply it to professors. How do you think public employee unions felt about that argument? They were angry with the AUP, as I knew they would be, for trying to carve out professors to have special rights that other public employees would not have. But I felt, you know, without the carve-out, it would be horrible for professors and the end of academic freedom. And in the decision, the Supreme Court left open whether this pursuant to official duties test, which it adopted, applies to professors. And I said that was a close call. Maybe our brief made a difference, maybe not. Since that decision, it's called Garcetti from 2006, the lower courts have divided, sometimes finding what they call a First Amendment exception to this official duties test. An academic freedom exception for professors. And other courts have not found an exception and have applied the pursuant to official duties test to professors in denying professors First Amendment rights. So there's a long answer to a long question.
Okay. I'll take
Putting part of the blame on you.
Sure, I'll take some responsibility ability for it. There is a carve-out in the decision that says, well, this logic for a district attorney's office, well, you know, you can make an argument that superiors should control that speech. You make an argument that they shouldn't. This may not apply to the academic setting, but it's ambiguous, and subsequent courts have used this bonkers theory. Like, how you think about a district attorney's office is not how you should think about a university, but it's kind of a wrench in the works here. So there's a need for the theory to avoid that kind of thinking, I think. I'm going to move along a little bit so we have some time for questions. I think this is really fascinating, but you end up saying a distinctive right of academic freedom covers scholarship. That has lots of implications in terms of funding or pre-approvals and things like that. It covers teaching. And that's not unbounded freedom.
Right.
And we want to talk about that. It also covers discussions within a university about university policy, say disputes about curriculum,
yes,
and so on, right? So let's just turn to some more practical questions. Let's take teaching. What can you do in the classroom? What can't you do in the classroom? What should the theory be? How should we think about what you can teach and what you can't do? Like, just let's briefly sort of handle that question.
Right.
Because I think people are interested in that question.
So my view is professors, and also I believe students to some extent, but professors should be able to decide how to teach their subject matter, as long as they meet academic standards as determined by professional peers, if that issue comes up. So deciding what books to assign, what writing assignments to assign, what theories to cover, that should be within the academic freedom of a professor. But academic freedom, right, to be justified, has to relate to the expertise of the professor and the subject matter of the course. So there's one case, this is an extreme case, but it makes the point. A professor teaching cosmetology, right, passed out pamphlets that contained religiously based objections to homosexuality. And the judge said, like, that's not protected. What do those pamphlets have to do with cosmetology? It's like teaching math in a law school or chemistry in an English class, right? You have to teach what's related to the course. Academic freedom doesn't extend that far. It's an obvious example, but it makes the point effectively, I think, that to be covered by academic freedom, you have to be, teaching your course within the bounds of academic competence.
Okay, and you also talk about what you call intramural speech and extramural speech, and we're still on professors. We haven't yet got to academic freedom for institutions as a whole, and we'll probably just touch on that briefly at this point, right? But so what's intramural speech, what's extramural speech, and how does your theory handle those things and, consequences for those things?
Yes, so as we've already discussed, the core of academic freedom protection is for teaching and scholarship. I think that's correct. But I believe academic freedom should also extend to speech by professors on educational issues facing the university, because I feel the expertise of professors that justifies academic freedom extends beyond their specific subject matter to their knowledge of general educational policy. So to extend academic freedom to that seems to me justified, though that's not the core. Now, with respect to speech off campus, or even speech on campus unrelated to professional expertise, I take the position, and it's very controversial, and it's contrary to the AAUP official position. In my view, academic freedom does not cover general political expression unrelated to expertise. The whole justification for academic freedom is that you need special protection for expertise in order to pursue and disseminate knowledge. What do professors know about general political issues that general citizens don't know? Maybe a political scientist has something specific to say. But just general political speech, I believe professors ought to have protection for that. But that protection should be under the general free speech clause of the First Amendment, the same free speech clause that applies to everybody. Academic freedom as a First Amendment right does not convincingly extend beyond speech related to the professor's expertise.
Okay, yeah, please.
I wanted to, it's working, okay, yeah. I wanted to get your take on what you mentioned earlier, Michael, the Stop Woke Act, right? Because it seems to me that there's an effort to challenge the idea of expertise with some kind of idea of the need for balance, you know, to have a diversity of viewpoints, and, you know, the argument coming from the right, you know, in the kind of example in Florida from the DeSantis administration is that, you know, certain viewpoints are not respected, and you know, clearly this also has to do with what constitutes expertise within an academic setting. So it's a kind of attack on certain disciplines, you know, such as women's studies, just to take one kind of example, or critical race theory. So how do you parse these efforts and how one might challenge them?
So just to say a little bit more about the Stop Woke Act, some of you may not know the details. This was a law passed in Florida that forbade teaching certain concepts in state universities in Florida, including concepts related to race or sexuality. And as the judge found in declaring that law unconstitutional, that's a very important decision. Under this law, for example, you could teach what affirmative action is. You could condemn affirmative action as a failed social policy, but it's illegal under this law to say that affirmative action is a beneficial social policy. And the judge said, that's unconstitutional viewpoint discrimination. I agree. It's also a violation of academic freedom because it intrudes on the professor's decisions about what's relevant and what's not, and what views are plausible within a field and what views are not. In my view, it's not the state legislature's job to make educational decisions about curriculum. To do so violates the academic freedom of the university as well as the professor. So the act, I believe, was unconstitutional, and the judge so found. I hope that's responsive to your question.
Yeah. Okay, so just could you talk a little bit about, it's a very complicated topic, but institutions as a whole, which raises the question of who speaks for the institution. You know, they have academic freedom to protect against intrusion from outside, but then also the people who speak for the institution could come into conflict with professors or students. And then, you know, they claim institutional academic freedom to make decisions, sometimes that are based on content or quality or consistency with educational values. You also say that you need a distinctive theory for institutions as a whole. That's a big issue with outside attacks on institutions now, right?
So in the 1970s, for the first time, the Supreme Court recognized academic freedom as a First Amendment right for universities as institutions, as well as for professors. The first justice who made this point, it's very interesting to me, the context, was Justice Powell, who wrote the decisive tie-breaking opinion in the famous Bakke affirmative action case. This case involved the legality, the constitutionality of affirmative action. This was in the 1970s. Okay. In the original Sweezy case that I mentioned from 1957, which first recognized academic freedom as a First Amendment right of professors, Justice Frankfurter, who had been a law professor himself and was very familiar with the issue of academic freedom, wrote a very influential opinion emphasizing that universities must have independence from the state. He said, right, it was crucial to prevent, this is almost a word-for-word quotation, it was crucial to prevent governmental intrusion into the intellectual life of a university. And to underline that point, Frankfurter quoted from a South African statement about academic freedom that was developed in opposition to the introduction of apartheid. So administrators and professors at South African universities protesting the introduction of apartheid relied on the concept of academic freedom as protecting the right of universities to make academic decisions. And this South African statement, which Frankfurter quoted in his opinion in Sweezy, and which then Powell quoted in his opinion in Bakke, identified 4 elements of academic freedom. They were the right to determine by a university on academic grounds, had to be on academic grounds, who may teach, what may be taught, how it shall be taught, and who may be admitted to study. And Justice Powell found the constitutional justification for affirmative action in that 4th aspect of academic freedom, who may be admitted to study. Affirmative action relates to that. Now, Powell emphasized you had to use affirmative action for educational reasons to bring it under the scope of academic freedom. But he recognized the First Amendment right of academic freedom in this context, and subsequent decisions in the Supreme Court and many in lower courts have recognized institutional academic freedom from government interference in many contexts. One more thing, I want that in the current context, and related to this recent legislation, to the Trump administration, recent developments. Maybe you want to get to that first, but I just, go ahead. Remember in the Sweezy case, Sweezy just said, I'm not going to answer questions about the content of my lecture. That's what the state attorney general was asking for. And Sweezy was protected in refusing to disclose just the content of what he was teaching. I want to emphasize that these recent state laws, and also demands on universities by the Trump administration, are going way beyond what the Supreme Court disallowed in Sweezy. This is not simply refusing to answer questions about what you're teaching. It's telling professors and universities what you may teach, what you can't teach, what academic ideas you can express, and what academic ideas you cannot express. This is way beyond what was protected in Sweezy. And that's why I come to the conclusion, people often think, the times we live in are, the worst or the best, or we emphasize the present. But even guarding against that, I believe attacks on academic freedom today are unprecedented in their severity. And that's, quite a conclusion given the concern about violations of academic freedom during the Cold War. But there, the target was left-wing professors. Now the target is universities.
Thank you for underlining that point. I think it's so important for everyone to hear, and I'm sure we're all very aware of it. I don't know if this is outside your area of thought or engagement, but I think one of the current problems is that universities are evolving, and that some of the current situation comes out of the fact that it's not simply an academic institution versus the government, but that there are boards of trustees who've often been quite willing to go along with what the government is insisting. And often these boards of trustees are not educators. So do you have any thoughts about how the educational institutions in the United States are being kind of reconfigured and how doctrines of academic freedom can cope with that transformation?
Well, this may challenge the presumption of your question. Well, it's not presumption that you were presumptuous in asking it, but the underlying assumption, right? The 1915 Declaration was written in large part in response to what it considered to be inappropriate trustee intervention into universities. And the main concern of the 1915 Declaration was inappropriate concern about trustees firing professors for disagreement with their academic views, not the government. The government became more important as a threat later. So the notion of trustee inappropriate restrictions on academic freedom, that's been there from the beginning. And I have the impression, many trustees today are in a difficult position. Some are hostile to academic freedom, pure and simple. But many, I think they believe in it, but the cost of resisting demands from the Trump administration are so great and so devastating to the educational work of universities that they're under tremendous pressure to comply. And I'm a big proponent of academic freedom, but I get it. They're in a difficult position. So take Columbia, because it's New York, and they complied with demands they should have resisted and would have won, I think, under First Amendment grounds had they resisted. The Trump administration threatened to withhold, my understanding is $800 million a year in research support for research done at Columbia universities. If that happened, hundreds of scientists at Columbia would have their careers destroyed. They couldn't continue their research. Even in the time it takes to protest the action and maybe get a good verdict, it takes a couple of years. And these people are involved in research. They need to continue it year by year. So there's a lot of pressure. Now, I think it's appropriate to draw the line on when the government is directly interfering with the educational process. And I think Columbia should have resisted, notwithstanding this concern. I'm proud that Harvard did resist. Yes, there's some very hostile trustees, but I think there are many trustees who are confronting like a really difficult situation, who understand what academic freedom is about, and who are probably reluctant to make compromises that probably we all think they shouldn't make.
Yeah, we have had at CUNY a number of controversies where, our high-level administrators are in this sort of bind, right? And some of them are just being cautious in advance on some issues. We're not talking about 800. Did you say, what was the
800 million is my understanding.
Yeah,
At Columbia. At Harvard, it's over $1 billion, I think.
And in Harvard, it was several billions, a couple billion, right? Okay.
1.2, I think, a year,
Okay.
but something like that.
Okay, so this is a really wrenching moment, perilous times indeed. Couple of points I want to add, and we're going to open it up, or if you had more, did you have some comments you wanted to make, or we're okay? Okay, good. Peer review is central to the argument. We haven't touched upon that. So you asked about trustees or presidents substituting their judgment for faculty peer review, and Professor Rabban is very comfortable saying that, yes, among the ranks of tenured professors, we find many, we find the human drama, and I said, maybe petty tyrants, but that's a better bet. Peer review is a better bet across the board. and that becomes important. A lot of the book is taken up with sort of tenure and promotion conflicts and how those play out. There's also an interesting theory about freedom of speech on campus, where we'll see if anybody has any questions about that. Professor Rabban is open to limitations on expression. I think that out on the walk, the rules should be the same as Times Square. Professor Rabban's position's a bit different than that some regulation of hateful speech, speech that degrades and excludes, we should be sort of open to that. But I'm sure maybe there'll be some questions about that we can take up.
I can say elaborate in one sentence.
Sure.
So, as some of you may know, American law is exceptional in the world in protecting hate speech. We can talk about why that is, but it is. People abroad, they can't believe it. They can't believe the amount of hate speech that is protected by the First Amendment. In my view, apart from protecting hate speech in the public sphere, and there are lots, I think, of good arguments for doing so, because the big problem is the government would call ideological speech it doesn't like hate speech and punish it. So that's a problem. But I think at universities, like people hurling racial epithets at one another, hate speech having nothing to do with the discussion of ideas, I think a university, in pursuing its institutional academic freedom to provide a good educational environment, and I think students have interests in learning that should be protected by the law, I think it's appropriate in certain circumstances for the university to punish hate speech, some hate speech that would be protected if it were uttered across the street, not on campus. But, and the line is hard to draw, in my view, any speech related to the discussion of ideas, right? A lot of that speech can be hurtful to people. But if it's related to the discussion of an idea, it needs to be protected. So that's the distinction I make. It's a hard line to draw, but I believe it can be drawn. So just very briefly on that issue.
Thank you. So we're going to open it up, but Professor Dawson has a comment or a question, and then I'm going to invite some audience participation. You've been very patient. Thank you. Go ahead.
I just have one last question, and that has to do with student rights to academic freedom, which you comment on in your book. I wanted to connect that to the question of the Palestine exception. We have a lot of Palestinian students at College of Staten Island, and we had a valedictorian last year who had to pre-record her speech because I think the administration was concerned about what she would say. So I wondered if you could comment a little bit on what academic freedom constitutes for students and what you think of that decision.
Okay, so I believe that academic freedom should be extended to students, though it really hasn't happened yet. There's a few cases that discuss it, but it hasn't happened the way it has happened for professors in universities. To me, academic freedom for students should extend to their interests in learning. The Palestinian speech does not relate mostly to student interest in learning, it relates to students' freedom of expression. So just as I think political expression by professors outside their expertise should not be protected by academic freedom, but should be protected by free speech, I would say pro-Palestinian speech by students probably shouldn't be protected by student academic freedom, even if it's recognized, but should be protected by student rights of free speech.
Okay, and just a caveat on the commencement, we're talking about that. The president stated unequivocally that the decision to pre-record was made before he knew the identity of the speaker. I'm prepared to take him at his word and still argue that it's a very bad look and it's not necessary, and that will be my argument.
Okay, thanks for that clarification.
I just wanted to report.
There's a notion in First Amendment law called like neutral time, place, and manner restrictions, and arguably that could be an example.
Well, is a commencement speech the government's speech or the student's speech?
Student speech at a university occasion, so that's what I'd say.
So it's not the university's speech, it's
No.
the student's speech.
Yes, but it's conceivable to me that the university might have interests in having the commencement speaker talk about issues related to the university and the student experience and, you know, sending graduates out into the world, and not use the occasion for a political speech.
Okay.
It's plausible. I mean, I'm not
Right.
sure I agree with it, but
Sure.
that's a plausible argument.
Right. Okay. So let me open it up. Like, do we have concerns, comments, questions? Please try to keep it to a minute and a half, or less. Less would be good. And if you're a student, you want the clue credits, the clue sheets will be outside. The reception's up there, but we're going to have about 10 or 15 minutes of Q&A. Go ahead, say your name and ask your question.
I'm Anjali. Okay. And I wanted to ask, you say that academic freedom doesn't cover political expression, which makes sense, but what if the professor is teaching a political course?
Are you a future law student? That's good. Yes, if a professor has academic expertise in the political issue under debate, then I say academic freedom applies because it's related to expertise. That's the key. If a chemistry professor is talking about politics, it's less likely that it would be related to the person's expertise, for example.
Yeah, I can't help but add, there's a couple of pages in the book where Professor Rabban is saying that professors need some leeway on this, that the test of teaching is it germane to the subject matter, and are you professionally competent, right? Those are the two main things. He writes about his chemistry professor on April 5th, 1968, devoting the chemistry class to a discussion of the assassination of Martin Luther King, and reports that although it was chemistry, it was perfectly appropriate and educational and actually a really important moment in your life, you say, yes?
I probably never had a more educational hour in my long education, but I'm glad you raised that. To me, it's the exception that proves the rule. Every now and then, something happens that is relevant to the students. Now, if this professor had spent the rest of the semester of chemistry talking about race relations, that would have been inappropriate. But for that class, under those circumstances, yes, I think the professor should be protected, and as he was in this instance.
My name is Jackson. Just a question to clarify. So, general political speech by a professor unrelated to their expertise, could they be, because it's only protected by the First Amendment, does that mean that they're only protected by intrusion by the government, but the university could fire them for that general political speech?
Yes, you've raised a very important question that I'd hoped we'd get to, and now we can, I think. So to emphasize, a lot of people kind of don't know this or lose sight of it, including lawyers. The First Amendment protects people from action by the state. The state. The First Amendment does not apply to private action, which means, for example, that the First Amendment applies to state universities, including the relationship between the administration and the faculty and students, but not to private universities. So is it Wagner College that's on Staten Island that's a private university?
Yes.
So a professor could not bring a First Amendment claim against the administration of Wagner, nor could a student. But a student here could, and a faculty member here could. One further point, though, Sometimes, right, as in the Florida anti-woke legislation, as in the Trump administration's demands, sometimes it's the government that makes demands on private universities and the students and teachers who work in them. And there's the state action if the government is putting the pressure on them. So where the First Amendment does not apply, it's to the internal relations at private universities. But, or and, some private universities voluntarily accept for themselves the restrictions that the First Amendment imposes on public universities. And if this were a law school class, I'd ask students, why might that be? But since it's not a law school class, I'll just give the answer, I think, which is private universities sometimes, maybe often, don't want to be perceived as affording fewer free speech and academic freedom rights than their public counterparts. And I can give an example from my own experience, but I won't given time pressure. I can talk during the reception if people are interested.
Great. Yes, hi.
My name is Gene, and the question I was having was you mentioned that. So a few weeks ago, my friend started. So after the assassination of Charlie Kirk, my friend started a chapter of TPUSA in this group, and then at this college, and then someone else also started a group of YDSA, which is Young Democratic Socialists of America. And then something I've been noticing is that like whenever TPUSA puts a poster, it always gets removed. Is that a form of a freedom of speech to remove someone's poster?
No. So there's public universities covered by the First Amendment this is part of time, place, and manner. Can say posting posters can be limited to certain places on campus. Like my own campus, there are kiosks where you can post things. I just visited a university, it's Carnegie Mellon in Pittsburgh. They have a wall where people can post messages, and people do. Now, most universities have such spaces, and to remove kind of political statements from those places, would be a violation of the First Amendment, if that's your question.
Thanks.
But to say you can't post one of those flyers, say, inside a classroom, that would be probably permitted because a classroom is for teaching, it's not for, expression of political statements. I can't hear you, sorry. That's it. Right.
Yeah, and I think a university could have rules and enforce them about tearing down other people's appropriately posted messages, right? If it's inappropriately posted, it might be a different. Yes. Okay, right. So maybe we should pay some attention to that.
I'm told to keep it brief, so we try to be as possible. So, but Michael began his presentation on the elite nature of distinguished professors, such as 145 over 7,000 professors, but actually that underestimates the elite category. We actually have 20,000 plus professors at CUNY, but 2/3 of those are super exploited, very vulnerable adjunct professors. And so I don't know if in your book, which I hope to get, if you talk about the attack around academic freedom on especially vulnerable faculty who are the overwhelming majority in higher education, and we've really seen that since the attacks on the Gaza Solidarity Movement. We have Tom Alter in Texas. I'd like to hear what you're doing at University of Texas for his case, but overwhelmingly it's been adjuncts that have been targeted for firings. And we have that right here at CUNY with the fired 4 at Brooklyn College, 4 adjunct professors who were fired. But they weren't even given the reason, but it was really because of their exercise of academic freedom.
So I don't have a separate section on this particular issue in my book, but I cover it in the following way. One thing is I emphasize the extent to which academic freedom as a substantive right depends on the procedures available to protect it. And I argue that in interpreting the First Amendment right of academic freedom, professors should have certain procedural rights against dismissal if they allege violations of academic freedom or free speech. The right of First Amendment academic freedom extends to all professors. Sweezy was a lecturer, okay? So the right itself, both in existing judicial decisions and in my theory, right, extends to all people who have expertise and who are teaching. The problem, as your question highlights, is a lot of good that right does to you if you can be fired so easily. And that is a valid point. That's an argument for extending additional procedural protections to the non-tenured.
Okay. I'll make this brief. Would you be able to discuss Jeffries v. Halston in light of protection?
Generally what?
Jeffries v. Halston. It's a Second Circuit case with Court of Appeals.
Yes, that's from a while ago. So let me see if I remember this correctly. Or maybe, since you raised it, why don't you describe the case and for everybody else and I'll respond.
Right, this was a CUNY chair who was speaking at an outside event and made comments that were perceived to be disruptive. And ultimately, he was removed from his chairship position by the by the Board of Trustees. And the decision there said, it applied the Supreme Court cases now to faculty, saying it was the potential for disruption of speech that was dictating the decision.
I'm glad you gave the facts because I'm familiar with another Jeffries v. Halston situation, but on this one, at a public university, this is general free speech, not academic speech, on campus or off. The same general First Amendment right that applies to everybody else should apply to a professor. Do I have a minute to describe this case at Stanford that's related to the question?
Please. Yeah, we can do another few minutes.
Okay.
Yes.
So I think this is a similar instance from my own experience. There was a professor at Stanford, tenured, who was involved in an anti-Vietnam War demonstration. This was actually on campus, but it was a central square on campus. This is like 1970. And during his speech, there were several thousand people there apparently. He condemned students, like coddled Stanford students, you think just by attending a demonstration and shouting some slogans, you're doing any good, you have to do more than that. He was talking like this. And apparently, he said, like, you see that building over there? It's one building you can see. You know what goes on in that building? Classified research for the Defense Department that's being used to commit genocide in South Vietnam. Like, we need to do something about that. Like 20 minutes, 30 minutes later, a small group of students who were at the rally went to that building, entered it, allegedly some damage was done. And the Stanford administration brought dismissal charges against the professor for incitement to riot. And this is what's so interesting to me. It's the example of a private university accepting standards that apply to a public university. Stanford told the faculty hearing committee, hearing the dismissal charges of this tenured professor, we want you to apply the recent Supreme Court decision on incitement, which is a very strict standard. Incitement is only, right, the direct and immediate incitement of imminent lawless action. That's really hard to prove. But Stanford said, we want you to use that standard, even though it's hard to prove, even though as a private university, we don't have to accept it. Interestingly, the faculty committee found the professor guilty of incitement and divided on what the penalty should be. The majority advocated dismissal, the minority advocated I think it was a year's suspension, something like that. But I think that's responsive to the kind of incident you were talking about.
So if a student or faculty member engage in First Amendment protected expression outside the university, there shouldn't be any consequences inside the university. So I'm thinking of the guy in Wisconsin who was making like pornographic videos with his wife, and he obviously shouldn't be chancellor. That makes sense. But should he lose his tenure position on the faculty? Professor was talked about in the New York Times magazine a few months back, who was making very pro-Palestinian comments, had tenure, was dismissed.
There might be a little difference between those two
You
examples.
think?
Pro-Palestinian, it's protected.
Well, they're both protected.
Well, there may, depending on the details of the, what you said, pornographic video?
Yes. Now, all right. Yes.
There may be some basis for like student concerns about how the professor might behave on campus, but it would be hard to make that connection, and that's the connection, in my view, that would have to be made.
Well, what about my alma mater? Professor Jody Dean made some comments I thought were, in my view, in my opinion, sort of outrageous comments about October 7th. She has the right to make those comments. She makes them on a blog, and that she didn't lose her position, but she was suspended.
Wrong.
Because students are afraid for their safety or don't feel comfortable on campus with those kinds of views being expressed by a faculty member.
I say the free speech interest prevails in that context.
But your reserve judgment on the guy.
Well, it probably prevails.
Pornographic video.
It probably prevails there too, but I could imagine certain facts that would make it questionable.
He should have been dismissed for making bad porn, not, if you're ever, never mind, I'm not going to do that.
Yeah, I'm not sure how much that's protected by your academic freedom.
I'm sorry.
Okay.
Is that a note to end on? I don't
No,
I don't think so. This has been fascinating. There are so many aspects to this. There's a lot we didn't actually delve into in the book, so I highly recommend it. I'm sorry I didn't get to everybody's desire to ask a question or make a comment, but please join us upstairs and we can continue the conversation. There's a very nice array of food and drink up there. Please join me in thanking our distinguished guest, Professor David Rabban, and our distinguished Professor Ashley Dawson for helping us out today. Greatly appreciated. And food sheets are back there, reception upstairs, and thank you all for coming.
Thank you for your attendance and for your excellent questions. Appreciate it.